SJC-12865, Harry de Prins v. Michael J. McCaley, trustee of the Donald Belanger Irrevocable Trust, dated October 28, 2008.
Thank you so much.
Mr. Rossi, good morning.
Good morning, Your Honors, and may it please the Court. My name is Michael Rossi. I'm here on behalf of the appellants, the Donald Belanger Irrevocable Trust, and Michael Michaels as trustee. The crux of the issue before this Court this morning is whether the death of the settler of an irrevocable trust makes a difference in determining whether a creditor has a right to access those trust assets. I'd like to discuss two reasons this morning why, in this case, Mr. Belanger's death did make a difference, and why it bars the reach and apply action that's been brought here by Mr. de Prins. The first reason pertains to the common law rule of creditors' rights and creditors' access to trusts. And in sum, the rule is that a creditor of a settler of an irrevocable trust may access the maximum amount of the benefits that can be distributed to the settler. After the death of the settler, that amount, logically, is zero.
Is there any question here that if he had lived, that they could get this trust corpus?
I think there's no question, Your Honor, that he would be able to access it. We recognize that, and there's no dispute on that point, that if Mr. Belanger was alive, that the creditor, in this case, Mr. de Prins, would have access to the assets. The key here is that his death changes the equation and makes a difference on a number of fronts with respect to the rights of the creditors to access what are now trust assets belonging to someone other than Mr. Belanger.
As a daughter.
Exactly.
Is it a statutory remedy only? Is that their only avenue? Because I know it's this particular circumstance is not covered by the MUTC.
Justice Bud, we would submit that it is covered by this particular section of the statute. It's our view that the way the statute is written, as particular it is, as it is, the legislature addressed, in its view, all of the different permutations that are applicable here. So the legislature, for example, addressed what would happen with a revocable trust if a settler is deceased. The legislature addressed what would happen with a revocable trust if the settler was alive. And the legislature addressed what would happen with an irrevocable trust, admittedly not specifying whether the creditor was alive or dead. But it's our view that if the legislature intended for a creditor such as Mr. de Prins to be able to access the assets of an irrevocable trust after the death of the settler, that provision would have been in this statute, and it's not. And it would not be, in our view, consistent with standard rules of construction to simply strike the word revocable from the statute and allow a creditor after the death of a settler to reach the assets of an irrevocable trust. In our view, the statute, with respect to irrevocable trusts, says all that it needs to say, which is the rule I just described from the Ware case. A creditor of the settler may reach the maximum amount that can be distributed to or for the settler's benefit. The logical extension of that rule is that after the death of the settler, the maximum amount that can be distributed is zero. There is no right to recover.
So I know no one brings this up in the brief, but the case seems a little bit different. The settler debtor killed the plaintiff's decedents. And so the reason he's not alive, when you talk about this irrevocable trust and it's protected because he's no longer alive, the reason he's no longer alive is because he committed suicide, which was obviously different as a matter of equity. And the reason there are creditors is because he killed the plaintiff's parents. What about equity?
Well, I think the important consideration here, Justice Lowy, in terms of equity is actually the rights of the successor beneficiary. And once Mr. Belanger died, regardless, respectfully, of the circumstances of his death, his beneficial interest in the trust was extinguished and his daughter's interest in the trust vested. She, of course, wasn't involved in any of these very unfortunate circumstances, and it would be inequitable, in our view, to deprive her of her rights to the trust property, which vested upon the death of Mr. Belanger, given those circumstances. And it's that sense of fairness, we think, that would be more of import here than the circumstances under which Mr. Belanger passed away.
So I've got a series of questions. Am I correct that if there were no trust, they could go after the estate for this money. They could sue the estate, and the creditor would get first dibs on the money.
Yes, Your Honor.
So it is only because he created this trust that that you argue it protects the daughter from essentially having to, it prevents them from having first dibs.
That's right, Your Honor. We would agree with that. And
So if he were alive and he created this trust, the law would say we're going to essentially ignore the trust. He could have gotten, the trustee could have given him all the money, and therefore the creditor would still have first dibs with regard to any money. It doesn't protect the settlor from creditors if he is alive.
that's correct, Your Honor. But I think the important point here is the reason why that is the case. And this is what was spelled out in the Ware versus Goulda case. The court there focused on public policy and held that it would be against public policy to allow somebody to tie up their money, allow them to use and enjoy and consume their money while depriving creditors of that same right. That is the underpinning of this rule that brings us here. That's the underpinning of the Ware case. And the purpose of that rule is completely eliminated once the settlor is dead.
Well, is it? I mean, why is there a public policy to say, well, if you don't create a trust, then your creditors come with the, I guess the lovely term is that equity, the person should be just before being generous. That in the absence of a trust, we would say you first pay your creditors, and then what's left over goes to your kid or your beneficiaries. Why should we say if you can create this trust, it's not going to protect you when you're alive against your creditors, but it will actually protect your beneficiaries from creditors when otherwise they would not be protected? What's the public interest in having a self-settled trust?
I think the important distinction here is that in cases where, dealing typically with a revocable trust, where courts have allowed a creditor to access the assets of a trust after the death of the settlor, which is the circumstance Your Honor is describing, in those cases the trust inevitably was revocable. It was essentially, as the court found in the State Street case, analogous to an estate. The assets of the trust were held by the settlor in trust, but not really, because the settlor had full access to the trust to determine who the beneficiaries would be, whether those beneficiaries were going to be changed. The settlor would have an opportunity to amend and revoke the trust. It was, as the court in the State Street case found, akin to an estate. This is a different situation. Here, Mr. Prins was not Mr. Belanger was not using this as an estate planning vehicle, so as he was gifting, in essence, his assets to his daughter. He relinquished...
No, he didn't. He could have gifted it to his daughter. He basically created a trust to gift it. If he had gifted it, he could have made her a beneficiary of his will and said, we'll go. But if that's the case, the creditor would get first dibs before she would. So he could have given her the money, and in that case, he wouldn't have any money, and then we wouldn't be here. But instead, he chose this trust vehicle, trying to essentially protect her from his creditors when she otherwise would not be, but for this trust. And the answer is, why should we, what public interest is there in allowing someone to do that?
I think the importance here is the timeline, Your Honor. There may be circumstances where the situation that Your Honor is describing would have, there would be a public policy rationale to allow that to happen. But this is not a case here where the settlor was defeating the rights of creditors that existed at the time he died. The timeline, very critical. This claim, this reach and apply claim, was not brought for years after Mr. Belanger passed away.
Not so strong, because he, after all, it just killed two people, and he probably wasn't thinking about the possibility of a wrongful death suit, but it certainly, after he killed them, if he had been alive, there'd be a wrongful death suit, and if he had not committed suicide, the creditors would be able to go after the estate. So he commits suicide, and now now you're saying, well, because I commit suicide, that means that my daughter will get the money that I otherwise would not get. So the public policy on your side isn't so compelling on these facts.
Well, the way we're looking at it, Your Honor, is that he At the time, the entire purpose of this rule is to prevent someone from having their cake and eating it too, and that's the language that this court and other courts have used. And once Mr. Belanger died, he could no longer have his cake. He could no longer use or enjoy the property. So
But having your kids benefit from your money that is part of what we want to do. That's maybe our biggest goal in life a lot of the time. So isn't he having his cake and eating it too? He's killing the victims and making sure they can't recover and making sure his daughter has all his assets. So isn't he having his cake and eating it too here?
Well, again, I think we need to look at what Mr. Belanger lost, or the detriment to him. There's no evidence in the record that he put this money in a trust to avoid creditors. He put the money in a trust months before these circumstances happened, and there's no evidence.
What's the timing? So the timing of the three things, the timing of creating this trust, the timing of the murder, and the timing of the suicide is what?
Sure. The trust was created in October 2008. The murder and the suicide happened within days of each other in March of 2009. And this claim, this reach and apply claim against the trust, was not brought until November
He
2014.
commits suicide right after he does the murders? I can't remember.
He did.
Wait,
Justice
and just to add, right, his wife committed suicide in October 2008, which was the same time that he created that trust, right?
I believe that's correct. Your
And,
Honor.
you know, from my reading of just what happened in the federal suit, he then spent the next several months tracking his victims, eventually killed them, and then killed himself. But before that, he did the trust. So I'm having trouble with you trying to argue about the public policy part. I don't think you have it. I think all you can really do is argue the legal part, right? I mean, to be fair, I mean, we all know what happened. So it's hard to say that there's a public policy reason for the estate to win.
We'll concede, of course, Your Honor, that the facts of this case are tragic and they are unfortunate, and certainly they're not ideal for looking at a specific legal question. But when I refer to public policy, what I'm referring to is the well-established rule that the reason a creditor of the settlor of an irrevocable trust during the settlor's lifetime can access that trust is to prevent the settlor from being able to enjoy that property while at the same time hiding it from creditors.
I understand that, but he got to hide it from creditors and give it to his daughter, I assume he felt like he had nothing left to live for. His wife had killed herself. He had committed double murder. So that's what he has left. So he actually did exactly what he meant to do. So I'm sorry. I think we should move on to another piece of this because you don't win the public policy piece. He got exactly what he wanted by doing what he did.
I'd be happy to address what I think is also a decisive point here, Your Honor, which is the statute from the Massachusetts Uniform Trust Code governing when and under what circumstances creditors may access the assets of an irrevocable trust. And there are two sections of that statute that, in our view, create a strong negative inference against Mr. Prins in this case. The first section, and I'm referring to Chapter 203E, Section 505. The first section of that statute that's pertinent here is Section 3, and that's the only provision that addresses the rights of creditors after the death, and it applies only to revocable trusts. The preceding section, Section 2, is the only section of the statute dealing with irrevocable trusts, and it does not provide that it applies after death. If the legislature intended for a creditor to be able to access the assets of an irrevocable trust, and that means a trust over which the settlor had no control over during his or her lifetime, that provision would have been in this statute. This was the time and the place to do it.
Well, doesn't your brother argue to the contrary that we shouldn't be trying to get rid of common law unless the statute's very specific about getting rid of common law? And isn't this common law rather than statute?
I think that's a fallacy, Your Honor, in the sense that there is no common law right for a for a creditor to reach the assets of an irrevocable trust after the death of the settlor, and that's what brings us here. If there was a clear common law right for post-mortem access to a trust after the death of the settlor, the question that the First Circuit has certified would have been resolved. There is no resolution to that question. It's our position that the answer lies within the Ware rule, which says that the creditor is only allowed to recover during the lifetime of the settlor the maximum amount that could be distributed to the settlor, and that amount at this juncture after the
And
settlor has died is
could you tell
zero.
me what the public policy reason is for that, in turn? What is the public policy reason for that?
For for the reason that a creditor may access the assets, I think
Well, no, I mean that the creditor can't access it after death. What is the public policy reason for that?
I think it protects the interests of the successor and the remainder beneficiaries.
So that's the public policy. We want to protect the person who would not otherwise be protected absent the trust?
I think that would be the primary one, Your Honor, but it may be more of a legal argument than a public policy argument, which is recognizing the significance of the trust and
As an estate planning device?
That's right. And whereas here it was not used as necessarily an estate planning device, but I think that's exactly the point, that there is a sanctity of a trust that ought to be respected, and there is, the law is not what Mr. Prins wants it to be, which is that there is clear and unfettered access by creditors after the death of a settlor who can no longer enjoy his property, who had no right to control that property during his lifetime, but once he dies, his creditors have free reign.
Can you, bad facts make bad law, and you've got really bad facts. So give us some facts. Give me an example where we would do an injustice here. Your client, there's going to be very little sympathy for your client. So, but we also don't want to create a precedent that's going to harm us. So give me an example of somebody who we don't want to deprive their kid of this. So give me, I just want to try to do the hypothetical the other way, because we've got to write a rule here.
Sure. I think the best way to look at that would be if we have a successor beneficiary who is the son or daughter of a settlor who did not engage in criminal activity but passes away from say, natural causes. And the trustee of the trust, upon the death of the settlor, is looking for some clarity, is looking to be able to, as our statutes and cases encourage, resolve the estate efficiently and expeditiously. So, as the
We have an elderly couple, and the man's got a debt, and he dies, and he's got $40,000, but he owes $30,000 to Baybank or something, and then his wife is going to be penniless. That's what we've got to protect against? Is that what you're saying, or is that not the case?
No, I think that's exactly it, Your Honor. And more than that, we also have to respect the role of the trustee here in administering the trust. What Mr. Prins is asking for here is for the trustee in this case to have essentially sat on the assets indefinitely, making no distributions, not spending any money at all to administer the trust, essentially in perpetuity, while he waited for a lawsuit that wasn't filed for 4 years after the death of the settlor to be resolved. And so the way we can help not only the beneficiaries but also trustees is to provide some clarity and some certainty that upon the death of the settlor, if there's no debt owed at that time, which would submit in this case there was not, there was no judgment.
I wouldn't go for your case, but I'm trying to imagine a case where we don't want to do this. But go ahead. Sorry.
So I think, I see that I'm out of time, but I think in that may be the crux of the issue, that the trustee of the trust is owed and it deserves some certainty and ability
But
to
we
administer.
could provide the certainty the other way. So, we could say, whenever there's a trust where it's irrevocable, but there's a debt owed, first you take the money and give it to the creditors. What would be wrong with that?
Because in this case, there was no certainty, there was no knowledge at all, no clarity about the amount that was owed. There was no judgment, there was no obligation at the time Mr. Belanger died or for years after to pay a penny to Mr. Prins. That amount has to be determined through our justice system, and it had not been. He was not a judgment creditor for years, and so there was no clarity at all for the trustee until at least 2014. And to us, it's incongruous and inequitable for a trustee to have to sit on the assets of the trust to the detriment of the successor beneficiary while that process plays out. In other cases, it could be even longer than 4 years.
Who said he had to?
Well,
This is not a reach and apply against the daughter, it's a reach and apply against the trust. So I assume that he did not distribute the money to the daughter. He was awaiting the judgment to be entered.
Well, there were no proceedings ongoing. So the question really is,
So the money did not get distributed?
oh, no, some of it was distributed, some of it was actually remained, and what remained has since been distributed to Mr. Prins. His argument is that the money that was distributed in the intervening years should not have been distributed, and thus that he is owed.
Okay, but the $750,000 is to reach and apply against the trustee or reach and apply against the beneficiary? It's reach and apply against the trustee.
That's right.
So he still has the money.
Well, the reach and apply is only so much as, or only as good as what assets exist in the trust. So the judgment entered against the estate, and part of that judgment simply acknowledged that collection of it would be in a reach and apply action against the trust. That did not mean that the trust was conceding that a reach and apply action would be successful, but it recognized that the estate had no assets. So the creditor, Mr. Prins, then proceeded against the trust beginning in 2014 after he obtained a judgment in the amount of $750,000 against the estate. He proceeded against the trust. So what I'm clarifying is that in those intervening years, there were some distributions made to aid in the legal defense of the trust, but whatever remained in the trust as of the date the judgment entered in this case by the district court, those assets were then paid over to Mr. Prins. His, and I won't speak for my brother, but the claim in this case is that there were not enough assets.
I'm sorry, but how much is in the trust? How much is Mr. Michaels holding?
Zero.
In the trust? Basically, he's already given it to Prins, and now the issue is whether Prins gets to keep it?
Yes, and more than that, whether in those intervening years, Mr. Michaels, as trustee, should not have made any distributions and should have maintained the corpus of the trust intact, so that at some point, if and when a judgment entered, the full panoply of assets would be available to satisfy that judgment.
Can you give us the numbers? So how much was transferred to the daughter, and how much was transferred to your opponents?
I don't have those numbers before me, Your Honor. I'd be happy to submit them separately if it would be helpful for the court.
Okay, and I guess I'm just trying to go back to Justice Kafker's question. So let's imagine a widower, 80 years old, learns he has cancer, decides he's going to go through his bucket list, incurs an enormous amount of debts, creates this trust. The trustees are out of luck after he dies. I mean, the creditors are just out of luck after he dies. All the money will go to his daughter, if you're right.
The difference here, Justice Gantz, is that in that case, the debt had been incurred prior to the death of the settler, whereas here, it had not been. There was no claim.
So this applies, well, the cause of action had occurred when he was alive. The judgment occurred afterwards.
The cause of action against the estate had.
But I mean, at some level, one could say that the debt occurred, much as if you spend money or got a credit card, the debt accrues. You may not get a judgment of collection till afterwards, but after he killed those two individuals, one can argue that the debt accrued as of the wrongful death. The wrongful death action occurred as of the time of the killing, correct?
Right, but the difference from the hypothetical that Your Honor posed was that in Your Honor's scenario, there was an amount certain. There was clarity as to the amount that was owed. There was perhaps a claim or a judgment, whereas here there was not. And also, and I understand, and this will be my final point.
But I just want to make sure the distinction you just drew, does it matter whether the debt is accrued after the creation of the trust as opposed to before it under our law, or would the same law apply either way?
In our view, it should not make a difference. I think the facts of our case put us in a better position because the debt had not occurred at the time Mr. Belanger died. But make no mistake, our position is that even in Justice Gantz's scenario, where a widower passes away having owed some debt to a bank, it's still our position that if that trust was irrevocable, if she had no ability to amend it, revoke it, direct dispositions during her lifetime, when she died, her beneficial interest in that trust was extinguished, and the interests of the successor beneficiaries vested, and the creditors would have no rights. Our case is better, but in that situation, we would take the same position.
Okay, thank you.
Thank you.
Mr. Dickinson.
Good morning. May it please the court. Mark Dickerson for Harry DePrins. Mr. DePrins would respectfully request this court answer the federal court's certified.
You knocked him off this chair. Good argument.
That's it. Blew him away with my.
I think
Yes,
we have a
good job.
chair malfunction here, so I will lean,
Which way are you leaning?
and lost the.
Uh-oh.
The judge I clerked for flipped over during oral argument, so this is next best.
stand for the balance of this.
That'll keep it
The
on
record shall
time.
reflect, by the way, that it was not me falling off the chair, it was the chair falling off of me, so just to.
And the record
I'm
reflects,
offended.
there's no evidence of sabotage.
No sabotage.
And full sobriety, so, that's,
Just note which justice was closest to him.
all right,
the
we'll
left
try
side or the
this
right
one,
side
we'll
with the
try
wood?
this one again. So if the question is which way Gantz is leaning, now you know the answer.
Decidedly to the left.
Okay, sorry about that.
Your Honor, I thought I was blowing you away with my argument, but I only said a couple words, and that is answer the question no. It seems for us, of course, for Mr. Prins, it's an easy question. We think this law has been settled for quite a while. The appeals court actually settled it. And interestingly enough, my professor at Suffolk Law, Professor Charles Rounds, author of the trustee's handbook, he took it over from Mr. Loring. He blogged about this and said that he thought that that essentially in the circumstance of this case, that the court should answer the question no. And he said that recently and said it because he thought that the settler possessed at the time a constructive general inter vivos power of appointment, and therefore his post-mortem creditor should have access to the subject property whether or not there was a spendthrift clause. And interestingly enough, Professor Rounds predicted this because I quoted from his 1994 version of the same, a different section of the trustee's handbook, where he said, the current trend of the law favors allowing settlers, post-mortem creditors, and the surviving spouse as well, access to the principal of the inter vivos trust if the settler reserved the power to consume the property at the time of his death. In the future, the law will evolve to the point where the settler beneficiaries, inter vivos, and post-mortem creditors will have coextensive access to the trust. And essentially, the appeals court has done your work for you. And I tried to persuade the First Circuit of this, that Calhoun versus Rawlings is almost right on point. In that case, what happened was you had a self-settled trust, and the real issue in that case was that trust truly self-settled, but you had a man who had been, unfortunately, in a motor vehicle accident that left him with a traumatic brain injury. He got divorced from his wife. A trust was created, irrevocable trust, spendthrift clause, and he had substantial assets in that trust. And then, unfortunately, he got into an accident with the plaintiffs in that case, and he was killed in the accident. So in Calhoun versus Rawlings, the appeals court essentially found that the creditors in that case, and again, there hadn't been any claim asserted at the time of his death. In fact, their claim arose instantaneously with his death, and yet the appeals court had no problem holding that the creditors in that case could reach the full extent of the corpus of the trust for the public policy reasons that it's established common law that essentially a self-settled trust is not a good device for asset protection.
Well, the only thing one might say in response to that, though, other than trying to distinguish Calhoun, is whether or not the statute, by implication, says otherwise.
Right. I find that a curious argument in the sense that, first of all, both Calhoun and Judge Hillman, the federal judge who handled this case, actually cited the Mass Uniform Trust Code in our favor because it does say, it basically parrots what the established law is, which is that a creditor can reach the full extent of a self-settled trust to the extent the settler has access to it.
Doesn't say what happens on the settler's death?
No, it doesn't. It's silent. And so I take that to mean, and I think there's a few reasons why it's silent. First of all, and I allude to this in our brief, but essentially the Uniform Trust Code and Massachusetts Uniform Trust Code just doesn't deal explicitly with that issue. And there was a reason for that, I'm a commercial litigator mainly, not a estate and trust person, but what I understand from estate and trust folks that I've talked to is that there's a different a device out there in the estate planning world, which is called the Domestic Asset Protection Trust. And those trusts are, there's a law review article by Brendan Duffy, volume 111 at 205, a Northwestern University law review article that describes these devices. And apparently, there's several jurisdictions, starting with Alaska, that have statutorily created something called the Domestic Asset Protection Trust, which would allow a self-settled trustee to, these statutes purport to fill this gap, which would give protection even though a settler is also a beneficiary. And so legislatures, including Alaska, Delaware, and most recently, I guess, Connecticut, have created these special statutes and gone out of their way
Which way do they cut? I'm sorry, which way do the statutes cut? Who do they protect, the
They're
creditors? or-
protecting the settler and allowing the settler from his creditors, essentially.
Okay.
That's what they purport to do.
And I, too, am not a trust maven. Is a self-settled trust the same thing as an irrevocable trust?
No, it could be different. An irrevocable
Well, you
trust,
said the Calhoun case deals with the self-settled trust, right?
it does.
So that's why I wanted to know why it is that that's not dispositive.
I think it is dispositive. I
But
think,
despite the fact the kind of trust is different?
well, it was, well, they were both trusts are exactly the same in this case and in Calhoun. They're self-settled, irrevocable trusts in
Okay.
which the settler had settled, provided the funds that ultimately were in trust that his trustee would then dole out for his support.
When you just described this domestic asset, we don't have it, protection, we don't have it in Massachusetts.
Massachusetts hasn't passed that, and
So would that would have covered the chief's hypothetical about the dying, but we have that gap in our law.
correct, but many jurisdictions do, and in fact, because they're somewhat controversial.
So let's talk about, we're stuck with our law for a second. So
Yeah.
if, in the chief's hypothetical, I understand all the equities are in your favor, but if we have a dying
Right.
debtor, he has an irrevocable trust, and he's creates this thing to protect his spouse.
Right.
So why should we still rule against that person too? Because that's harder than this one. I just want to make sure why we should
It
be
is,
doing.
is much harder, but, essentially, it's a public policy argument, and it goes back very deep into the common law here, back to the Hill case we cite, and Chief Justice Rugg in the Shattuck case also cites it, which is the maxim, you have to be just before you are generous. And it's a very well-developed and long adhered to principle in Massachusetts on the theory that, one cannot, a man of integrity who's got assets, when there's a decision in the case, I think the Shattuck case talks about, it's really of a power of appointment.
We've decided cases where, again, you owe money to the bank or somebody
Correct.
else. We've decided cases where even in those sort of sad situations, we still protect the creditor.
I can't recall if there's sad situations, but this court has decided very similar cases where basically they've made that policy choice already. And the policy choice is, are we picking the creditor or the intended beneficiary, the innocent intended beneficiary who's really down and out? And you've consistently come out on the behalf of the creditor. And I would also commend you to, this
Statute goes the other way, though. The statute, the DAPS, the domestic asset protection, that chooses the other policy.
correct.
So that's contrary then to the professor's notion of how the law is going to evolve, right?
Well, I think the professor was talking about how the common law
Common
would
law,
evolve. And
not
I don't
the-
think he was speaking to these domestic asset protection
Okay,
trusts. I think
all right.
those are a unique issue. And to get back, I think that the reason the Uniform Trust Code, that, we started down this road because the argument is that there's a negative inference from the Uniform Trust Code. I think they recognize that there's this conflict between the common law
That's why they're silent.
and
Is
their
that-
silence, correct.
Okay.
And so I don't think they purposely not addressed it, and I don't think you draw
So
any
is the-
negative
Is
inference.
the common law, it's an equitable action, so would we have, is there some flexibility where we can decide in favor of your client and leave undecided the, the dying cancer victim case?
I think there is, especially in this case. I think you could decide this case purely on the public policy that what happened here was, Mr. Bellinger set up this trust. I think
We're turning to this maxim just rather than generous, but it gets a little more complicated in other factual
it does.
circumstances.
I agree with Your Honor. So I think you could simply say, in this case, had Mr. Bellinger lived, he would have been able to enjoy the fruits of that. Here's a hypothetical. He's killed Armand Simone de Prins. He's driving on his way out of Sholto, Arizona. He decides to go to Las Vegas. He calls on his cell phone, Mr. Michaelis, and says, wire me, I can't tell you why, I need $100,000 because I'm going to Las Vegas. He had the ability to do that. He also had the ability to say, Michaelis, I did something terrible. I want you to take care of Mr. DePrince's family and wire that money immediately to them. He had that opportunity. He did not. What did he do? He instead he was driving purportedly towards Connecticut and committed suicide as an officer approached his vehicle, and he took, by the public policies against suicide, obviously, and he took that destructive act, and that's the act, that now purportedly puts these assets out of the reach of the DePrince family. So I think on that public policy aspect alone, you could decide it. But I think
Does that answer the certified question, though?
Excuse me?
Does that answer the certified
I
question?
think it does. Well, you still have to answer I think you have to answer it no. You're right.
but?
You're right, Your Honor. I think you could maybe craft it in a very limited, under the facts of because the question is under the undisputed facts of this case, and those are the undisputed facts that Mr. Bellinger committed suicide. You could do that, or I don't think there's anything wrong with making the public policy pronouncement that creditors should be favored over self-settled irrevocable trusts beneficiaries.
So if we don't do anything, though, other than say, well, the equities favor your client, so that's going to determine this case,
Right.
then when we have trusts being written and we have this issue being addressed, they're going to look at Judge Hillman's case in federal court for guidance.
Right. Well, I think obviously now you need to weigh in, and I think what I was going to commend to the court is, the Supreme Court of Illinois decided these principles in their decision that we cited to you, the Rush University versus Sessions case. They went into the surveyed the common law and came to the conclusion. I think they weighed the decision, the issue that Judge Kafka has brought up, which is, do we choose between the creditors and the innocent beneficiary? And they say the law, the great weight of the common law says you got to weight the public policy demands you find in favor of the creditors, because the settler here was having his cake and eating it too.
Yeah, now, going back to Calhoun, in Calhoun, the analysis from the appeals court doesn't really focus on the settler's death as far as its impact on the creditors. Is that right?
That's right, Judge. Interestingly, I guess we won't know because the record's not clear. I could speculate that maybe the lawyers thought the law was so settled in this area that they didn't even raise that argument, but the court did not address it directly. But I think that the general principles announced in that apply here as well, and you would be making an incremental step and essentially blessing the outcome of the Calhoun versus Rawlings case as well, and just establishing that self-settled trusts are not good asset protection devices. And again, coming back to what would have been a good one is, had Mr. Bellinger really, wanted to have these assets truly go to his daughter unencumbered, he could have gifted them to her. He could have done that. Especially on the record, what's going on here, the timing is very much weighs in our favor in the sense that the precipitous action was that there's a legal dispute with the DePrince family and the Bellingers, and they moved away because of that to California, and then the wife commits suicide, and that triggers within a week, Mr. Bellinger's calling, informing this trust of his wife's suicide. And then it's, the record's clear from the affidavit of the daughter, he was despondent at the time he was creating the trust and thereafter, and he was suicidal. He was clearly contemplating the end of his own life. So I
So
think,
you're saying that if he had gifted it to his daughter, you couldn't get it from his daughter?
well, I wouldn't go that far. I think
I
we
bet
probably
not.
would have, we would have probably taken, or at least my, my colleague in Arizona likely would have brought some sort of fraudulent conveyance action. But yes, for our purposes, I don't think, we certainly wouldn't be here. And
To reach and apply something?
right,
Can I ask, just in terms of the amount?
Sure.
The 750,000 was the total amount? And
all right. So it's a little fuzzy, but I'll give you the best I can. I've been more involved in the case. Mr. Rossi came in essentially on the appeal. So there was, we believe, about over $500,000 was put in a trust and under the care of Mr. Michaelis. And our rough numbers, our understanding are that during, and that was basically from the reach and apply case. You know, that's the numbers that we know of as of like 2015 or so. And then since then, I would think, my rough numbers are about 100,000 was doled out over time to the beneficiary, the daughter, Bellinger's daughter, and the great bulk of it went to pay Mr. Michaelis, who was defending this. And there is a parallel action in federal court pending where we say that was excessive amounts taken out of the trust for the legal defense. And then at the end, when we finally received summary judgment, there was over $120,000, maybe more, approaching $150,000. And there's a dispute about that amount because about $75,000 was given to a law firm, not Mr. Rossi's law firm, but a Worcester law firm to hold as a retainer. And we don't have an accounting as to how much of that was depleted or how much is being held by that law firm. But we did, from Judge Hillman, receive an execution, and my client has actually received about $75,000, or maybe more like $73,000.
But it's still on appeal?
But it's still on appeal, that's right.
Okay.
If there had been no trust and the money had gone through a will, is it a matter of common law or a matter of statute that says that the creditors have first dibs?
I think a matter of statute in Arizona. In fact, just to be sure about the record, and this isn't the record, but there was actually a wrongful death action against the estate, and the estate just didn't have enough assets, and that's why a stipulation was reached in Arizona of judgment that against the estate, allowing the plaintiffs to reach and apply to seek the assets.
So the legislature, in the absence of the existence of a trust at least, has made clear that it wishes the creditors to come first
Right.
when there is to be a transfer upon death via the estate.
Yes, I believe so, yes, sir.
And that's the case in Massachusetts as well as in Arizona?
I believe that is the case, Your Honor, but again, I'm more of a litigator than a estates and trust specialist, so,
Okay, thank you.
thank you.
All right. Hear ye, hear ye.